Hello and welcome to Healthcare Matters, the internet television program that explores the intersection of medicine and the law. I'm your host, Mike Matre, editor of the Medical Liability Monitor. The repeal and replacement of the Patient Protection and Affordable Care Act of 2010, also known as the Affordable Care Act or Obamacare, has been the hot topic in D.C. as well as the healthcare industry since the election of President Donald Trump. While no consensus bill for replacing the Affordable Care Act exists at the time of this taping, the medical malpractice insurance industry has been anxious to see whether the GOP's legislation will include medical malpractice tort reform provisions, something not included in President Obama's signature healthcare law. Today's guests on Healthcare Matters, Congressman Phil Rowe and Andy Barr, are here to discuss the American Healthcare Reform Act of 2017, which they introduced in January. Both men have been intimately involved in the creation of previous bills that would have repealed and replaced the Affordable Care Act, each of which include a safe harbor provision that would shield physicians who follow best clinical practice guidelines against malpractice claims. Representative Rowe, a board-certified obstetrician and gynecologist, is the sponsor of the American Healthcare Reform Act, and Representative Barr, a former liability lawyer, co-sponsored the bill as well as helped craft its medical liability reform provisions. Both Rowe and Barr have previously worked with now Health and Human Services Secretary Tom Price in crafting previous replacement bills that also contain safe harbor tort reforms. Because of Secretary Price's influence and the fact that he will shepherd any consensus legislation through the House and Senate, it's likely any medical malpractice reforms will center around creating a safe harbor for physicians practicing within clinical practice guidelines. Welcome to Healthcare Matters, Congressman. Prior to your election to Congress, Representative Rowe was a practicing obstetrician and Representative Barr a medical liability defense attorney. Could you briefly share how the medical negligence portions of the American Healthcare Reform Act was informed by your previous professional experience?
Well, I'm a board-certified OBGYN, and I began practice in 1977. My malpractice premiums were $4,000 a year. And it was over $50,000 a year when I stopped delivering babies. And as I got up here in D.C. and began to work on healthcare reform, I was asked by the Republican Study Committee to write a Republican alternative to the Affordable Care Act, which I got a group together, a really solid group on my committee, and put this together. And I thought, well, it wouldn't be complete without a malpractice piece, because the defensive medicine that's practiced in this country is enormous. The amount of testing we do that I believe is unnecessary, simply because, you go into an emergency room today and you say your belly hurts, you're going to come out glowing in the dark. You're going to come out with a CT scan and ultrasound most likely. And years ago, you came out with a multi-$1,000 bill. And did the quality of care go up that much more? And my answer to that is no, it is not.
The reason why we need this is because defensive medicine is producing overutilization. It's driving up costs, and not just increased medical malpractice premiums, but also increased healthcare costs because of overutilization. The litigation lottery environment that I was exposed to in private practice, both on the plaintiff side and representing hospitals and physicians, was evidence enough to me to know that there's a whole lot of wasteful expenditures in the administration of healthcare services that are not only unnecessary but not medically indicated, simply for purposes of protecting doctors, hospitals, and nurses from frivolous lawsuits. So we think that the best way to go about this is to provide a safe harbor for those healthcare providers who adhere to clinical practice and diagnostic guidelines. And frankly, that gives these are peer-reviewed, evidence-based guidelines. We think the argument to the plaintiff's bar and to patient advocates is this: people who are concerned about actual medical errors, that this would actually raise and standardize the standard of care nationwide. And at the same time, it would have the effect of weeding out frivolous claims early in litigation.
The hospital medical professional liability industry has consistently said non-economic damage caps are the most effective tort reform for reducing the cost of medical professional liability. And they've also been consistently against safe harbor legislation. You removed caps from the 2013 version of the American Health Care Reform Act and added safe harbors. Why?
It's just a bridge too far. And if we knew we could nail that bridge, we've tried it over and over. No one has ever been successful. And I think, and in Tennessee, we have $750,000 cap on damages, which I think is going to be ruled unconstitutional when it's finally works its way through the court system. So unless it's in the state constitution, which is what they did in Texas, it's probably going to be ruled unconstitutional and be thrown out anyway. And so you get what you can get, and basically I think this is pushing it as far as we can get it, and this would be a great start.
So I don't have a problem with caps, but here's the reality: is this piece of legislation is ineligible for reconciliation under what's called the Byrd rule in the Senate. Now, this is kind of technical, and it's inside Senate rules, and but it really matters in terms of what is actually achievable. And so there's certain things we can do in the repeal and replace agenda in reconciliation. There's certain things that Secretary Price can do administratively at HHS. And then there's a third category of healthcare reforms as part of the ACA replace agenda that need to move through regular order. That means that there's federal law changes that require 60 votes in the Senate. This is one of those. And so in order for us to have a chance to bring 8 Democrats along, we have to be sensitive to some of the objections or concerns that have been raised in the past. The pretty uniform opposition to caps on non-economic damages among Democrats. So it's really an effort to attract to have an innovative form of medical malpractice reform that can attract bipartisan support in the Senate, and we think it would also have the effect of limiting the defense of medicine, even though there are no caps on damages.
Representative Barr, can you explain how this legislation satisfies those legislators who support the concept of federalism and states' rights while moving many medical liability claims out of the state-based civil court system?
What we do in this is we address the federalism concern by saying we recognize that tort law and medical malpractice litigation is traditionally within the jurisdiction of state courts, but there is a strong federal interest as a payer, that the federal taxpayers have a strong interest in preventing overutilization of health care, lowering costs for the taxpayers, and preventing defensive medicine. And therefore, for any malpractice claim that arises under a federal payer or a federal statute, the defendant should have an elective right of removal to federal court and avail themselves of this safe harbor provision. And so that's how we get around the federalism issue, because we're dealing with cases where there is a federal interest.
Is there an ideological barrier to ever getting a federal cap on non-economic damages? You mentioned how your legislation sidesteps the concerns of federalism and the 10th Amendment, so would it be possible in the future to similarly pass some sort of floor cap on non-economic damages where states could adjust the cap downward if they like, but there remains a nationwide backstop of, say, $500,000 or $750,000?
It's 167 or 157, I think it is. And that's how many lawyers there are here in the House and Senate. Mm-hmm. And the problem is getting it past that. You will never get the caps passed here. It's just not possible. And so what we thought about, Andy and I talked about, was that, hey, he wrote this bill, and I said, well, that maybe threads the needle that we could get enough support from the conservative attorneys on the Republican side and some bipartisan Democrat support that we would be able to do this. If you put caps on it, it's dead. Okay. And I can tell you, we've tried it, and it goes nowhere.
The medical professional liability industry is concerned with safe harbor legislation because a savvy plaintiff attorney could convince a jury that any deviation from the clinical practice guidelines your bill intends to implement would be malpractice. In essence, taking the standard of care from local to national.
If you're in a Medicare situation right now, you have a national standard, like it or not. And we let those standards be set not by us, but by the medical specialties that take care of it. Like if it's American Society of Internal Medicine or the ACOG in my case, or the American College of Cardiology, whatever, neurosurgeons, whatever. They're the ones, not somebody else, that decides what those standards are. And I've heard that argument, and I totally agree with that, but this would be what we would do to help, to hopefully help thread the 10th Amendment needle.
I'd like to thank both Congressman Rowe and Barr for appearing on Healthcare Matters. The potential repeal and replacement of the Affordable Care Act and its effect on the healthcare system is obviously a continuing story, and I hope to have both gentlemen on again as legislation moves forward.
Thanks for having us on.
Thanks a lot. Bye now.
To make certain you don't miss future episodes of Healthcare Matters, please subscribe to our channel by clicking the button at the bottom right-hand corner of your screen. And for more in-depth reporting on the medical professional liability and risk management industries, please consider subscribing to Medical Liability Monitor, a monthly newsletter that delivers the latest information on medical professional liability insurance premium rates and trends, tort reform, significant jury verdicts, and what's happening with professional liability insurers across the nation.